guys, it's Kathy. I hope you're doing well. Martha, you look beautiful today. Jeez. Save some men for the rest of us, will ya? Come on. Alright. I got more for you today. But I guess, listen, we need to talk real quick. Because I need to know what you guys would prefer. Alright? So, because I moved so far away from where we all work, and because my son totaled my other car, I have one car to get 3 people to work an hour away every day, and we all work different freaking shifts. So my mornings look like at 4:30 I start streaming. As soon as my stream is over, we all get in the car, we head to Lancaster. I get off work around 5, but my son doesn't get off work until like 9. So instead of driving an hour home and then driving an hour back to pick him up, we've just been staying in Lancaster, pick him up at 9:30, between 9:30 and 11. He works in a restaurant. And then come home. I usually get home around midnight. And then my stream starts at 4:30. And I need to gather content for it. So if anybody here can do math, it's not exactly sustainable. So I would prefer to stream every morning still. I'm not at all saying I don't want to stream every morning. I would prefer streaming every morning. The problem is I might not always have time to find the content. I might have to just play a docket without even seeing it first. Oh, my cat is currently scratching my new... Oh, doesn't matter. I love the cat. I'm not gonna... Anyway, which means some days we might get some boring content. Or I can stream fewer days a week and I would have time to find the content. So I would prefer to continue streaming every morning and put a docket on and talk and chat. But if that sounds too boring for you guys and you guys need me to find the content, then I'm going to have to cut my hours down a bit. So here's what I want. If you don't have an opinion... Oh, yeah, sorry, blank screen. If you don't have an opinion, then you don't have to say anything. If you have an opinion either way, throw it in Discord and let me know what you prefer. If nobody says anything, then I'm just going to stream every morning, and hey, some days it'll be good and some days it might just be boring. I don't know. It's temporary. As soon as we get another car, there's a couple things going on I can't talk about because I have some assholes that watch my stream and they interfere with my real life. But this is temporary. My move was my first step. I just need to get a few things in order. So, if you guys do not have a preference either way, I'm going to stream every morning whether I find content or not. I'm just like we put Judge Fish on the other day, I'm just going to pick a judge and we can watch him until I make myself more time. No, Micah, I didn't give you an opinion on anything else. You have an opinion when I give it to you, sir. Sir. That's the way it works. And Martha, God, you still look gorgeous. Okay, guys, buckle up. Because I did find stuff for today. Here we go.
Yes, you sit down now.
Yeah, of course. Very good. What if anybody knows that I poison in southern medic? Everybody with propagated bacteria from like blood in my belly button. Belly button bacteria has never before been seen on the face of the planet. So it's a skin because of massive.
The case hasn't started yet. He's just talking to his lawyer, so I grabbed this part. The audio and everything gets great once the case starts. But right now we're just listening to this guy talk to his lawyer. The guy we see in Zoom, that's his brother. Okay?
In fact, just about your lymph nodes, every system will put to spaghettis and absolute massive infection. That's unlike any stat. Actually, registered first. If you put a pencil inside of the toilet water that you get and inject that into somebody's skin and antibodies, that will also cause massive infection. We don't know that I have a possibility. When your people understand how easy it is to give somebody a serious staph infection, with the worst piece of wood, or just, put it underneath your fingernail. Does anybody understand what it is to give somebody a super infection and what it is to cook it inside of their own body? Does anybody know how easy that is to get cut under the thumbnail? You just start, and there's a lymph node right there, and then you just start putting in all kinds of bacterial strains into it, which will cause your body to get a fever, which will cook that bacteria. Es en español. Yo necesito por favor, eso. Well, listen.
The judge just gave him a look. That's going to tell you how well this is going to go.
Importante, yo hablo español, pero leyendo eso muy difícil para mí, ¿eh? I'm not sure this. I have looked at the never doing it, spend all of this time in jail because what I would do is I would cook a soup with bacteria and it would infect people with it very easily. I'm not going to have my constitutional rights violated anymore.
Morehead.
I will not have my rights violated anymore. I will act in self-defense. Second Amendment kicks in at that point when the law refuses to back me up. But you can stand next to you.
Your Honor, we're ready to call Mr. Daniel Morehead.
All right, 26 CR 1056, People versus Daniel Morehead. Entries of appearance, please.
Rafe Taylor on behalf of the people.
Elena Engel for Mr. Morehead. Mr. Morehead appears in custody today. Your Honor, we received a report from Dr. Cantorna opining that Mr. Morehead is not competent to proceed. Today, I'm asking the court to make that finding and order inpatient restoration services.
All right, do the people have any objection, request for second evaluation, or request for hearing?
We do not.
All right, then in that event, the court, upon the basis of the report that was filed on June 5th, will make a determination of incompetence to proceed with a substantial probability of restorability in the foreseeable future. At this time, the
I
court.
also refuse to take medication. Sorry.
Okay,
In accordance with my First Amendment right to follow my religion.
All right, thank you, Mr. Morehead. This morning, the court will enter an order for in-custody restoration services to commence. And apart from setting this matter for a 91-day review with appearance, are there any other requests from the defense this morning?
No, but I do want to make a further record. Mr. Morehead has made clear to me that he wishes to request a second evaluation and he wishes to contest the court's finding of incompetency under the applicable case law, which I believe is Davis 352, Pacific 3rd 950. I don't believe Mr. Morehead in his current state, given that he is represented by counsel, is entitled to make those requests, but I did want to put that on the record today.
May I make a
All right, anything else from the people on this case?
No, Your Honor, thank you.
Well, because you can't just tell somebody that they have mental illness and things like that, and then give them no way to contest that.
All right.
I mean, that would be a violation of all kinds of things when you think about that, when I have the right to equal representation and all kinds
So
of
we're all done for today. Okay, we're just.
Yeah, Mr. Morehead, what I'm going to.
Throw everybody in the fucking jail.
Is that a Monday? Just 1 second. Monday's perfect. Thank you, Zach.
I'm sorry, can I have that date one more time, please?
14th, 9 a.m., Division 302.
All right, just for the record, we had an outburst from Mr. Morehead. He has been physically removed from the courtroom for the remainder of today's hearing, and the court will find that he has absented himself by way of his behavior for the remainder of the proceedings. All we've got to do is set the next court date. So the court has issued an order for in-custody restoration. We will plan on seeing Mr. Morehead at the next setting. Are you asking for a virtual appearance for the next setting? Or do we know where he's going to?
I don't know. Mr. Morehead really wants to come to court, so that's my request.
Yeah, I've got obvious concerns bringing him over for reasons that are not 100% necessary. Under
Right.
the
I represent Mr. Morehead, and that's his request, is what I can say.
All right, let's do a virtual appearance next time, given the outburst today and the court's concerns with respect to that. If we have any kind of substantive hearings moving forward, we'll of course bring him over to the courtroom. But for now, given the purpose for the next setting, we'll do a virtual appearance.
Your Honor, before you conference, I think they have a phone number of Mr. Morehead on the letter. I just wanted everyone to support his attention. Is the event that the family members want?
All right, I've unmuted the account, Don Morehead. Good morning, sir. How are you?
I'm all right. How about you?
I'm okay. Just wanted to make sure that you didn't have anything you wanted to bring to the attention of the court this morning.
I've been dealing with this for several years now and tried every avenue. I cannot tell how many times I have called crisis management. We've tried taking him to a hospital. All of this started happening when he went off medication. And just to see him outburst like that in court and to hear him, it's breaking my heart. There's nothing that I wouldn't do for my brother, my twin brother. And I'm just imploring the court, please help him. Please help him. He doesn't need to go to prison. What he needs is medication and some serious mental health treatment or something.
All right, thank you, Mr. Morehead. I'll note for the record that's Don Morehead. He appears via WebEx this morning. Mr. Morehead, I did just enter an order for in-custody competency restoration services to commence. And those will be through the state hospital. And so with respect to restoration, those will be efforts to restore him to competency. Oftentimes in the event that someone refuses medications, there will be litigation around that to compel the receipt of those medications during the restoration process. So with respect to where we find ourselves legally this morning, that is the ordinary course of business when someone has been found to be incompetent, and it is the court's hope that those competency restoration services will result in the kind of progress that we have not seen thus far.
Is there any, no, thank you, Your Honor. Is there anything I can do to assist with this at all?
I can't give you advice as far as that goes. To be perfectly honest, there's not a whole lot that an individual in your position can do under the circumstances. There will be an initial evaluation, or there will be a next evaluation from the state hospital at that 91-day review. We'll check back in on the status of his competency at that time. If he's found to be restored, the case will continue on. In terms of your statements regarding the outcome of the case, that's something that will be determined among the parties if and when the competency stay is lifted. But for now, it's just a matter of restoring him to competency, and that exists almost exclusively within the Colorado Mental Health Hospital. So the services
So he will most likely go to state hospital?
That I can't tell you for sure. It's a possibility that he would be restored in the Arapahoe County Jail or in some other facility, but that's yet to be determined. So we'll have to see exactly where it is that the restoration services occur.
Okay, thank you very much, Your Honor, and thank you for acknowledging me. I appreciate that very much.
Of course, I'm sorry that you find yourself in the position you're in this morning, sir. Have a great day, and you're welcome to return for that next setting.
All right, thank you very, what day is that?
On the 14th at 9.
September 14th. All right, September 14th, 9 a.m. That'll be back here in Division 302.
Okay, thank you very much, Your Honor.
All right, have a great day,
And
sir.
thank you, guys.
With that, the court will be off the record.
You know, there's lots of people in this that goes through this. They have someone in their life that is just they're mental like that, not taking their medications, and they have absolutely no resources, no help at all, especially when they get, manic and they get into an episode. It's frustrating for them. Now this guy's going to jail, but he probably just needed help. But you can't really help someone who's not going to take their meds. You know what I mean? It's just impossible. All right. Let's see. Then we're going to stay in this vein.
So, Ms. Lanahan, you're here today on a request for a temporary protection order. I have reviewed the complaint that you had filled out and kind of have a basic understanding as to what's going on, as well as a concern that you have for your dog. In this case, what I'm going to do is I'm going to swear you in, and I'm going to go ahead and have you kind of tell me what's going on and why you believe a temporary protection order is necessary. Okay? Let me have you raise your right hand. Do you swear or affirm under penalty of law the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Why don't you go ahead and tell me what's going on with
Yay, Lacey. That's so awesome.
regards to Mr. Lopez?
So he goes by nickname Tony, which everyone calls him, but full legal name is David Anthony Lopez. He has been staying as a guest temporarily, and he does have some mental illness. He is bipolar. He has stated that he's not on his medication. I'm not quite sure for the duration of time. And he has expressed, or he's been doing behaviors that are very concerning.
Can you tell me a little bit about those? I know you wrote about them, but
Yeah. So leading up to the incident, he informed some of us in the house about belief that he has people that are trying to blackmail him, come after him in some way, that he's taken the SIM card out of his phone and turned it off. However, even though he has wrapped it in tinfoil and put it in a saucepan covered with a frying pan, that they are still trying to contact him. And he has been drinking every day. I feel like it's been getting heavier and heavier as the time went on. And he's just been kind of causing disturbances, including disturbing our neighbors. We do have a text evidence of their concern. They're the neighbor to our left. And when he started to get very loud and hostile on Thursday night, he was in the room with the door shut, and we could all hear him around 10 o'clock, that he was being very angry and cursing people out, threatening harm, threatening that he knew how to make a bomb and so forth. One of the housemates, Edward Reed, he is the one that had brought Tony into the house. He and my ex-husband, they firmly, but didn't bang on the door. They were just trying to get him to come out and let him know that this isn't accepted. To my understanding, that he did have some kind of a brief discussion with him previously. He paused with his screaming and yelling and slamming, opened the door, screamed in their face, and slammed the door. The cops were called, and I was advised to wait outside and, further away. And so while we were waiting, more cops had come and arrived to the scene. And so there was about like 6 or 7 cops at that point. And the end result of the night is that because he hadn't like physically done any harm, that they couldn't do anything. And that because he had a piece of mail addressed to him received at our house, that he is technically a resident. He is not on our lease in any way. And we're also just tenants on renting a house on that lease. I felt greatly terrified. And I actually had someone come and pick me up and remove me from the situation. This was Thursday night around midnight. And I've been in communication with my ex-husband, a little bit with his father. He stated that Tony continued to be very loud and aggressive with his speech and threats and slamming things up until 5 o'clock the next morning. Police had been called again. However, unfortunately, same result was they were not able to remove him from the house. He because he is bipolar and not on his medication, his mother, her name is Kathy Lopez, the sister of Ed. So Tony is actually a cousin, like distant cousin of some way. She requested a welfare check because she expressed that he was suicidal due to a history of suicidal attempts. And so a welfare check was made. Nothing came of it. And when I was on my way to returning yesterday evening, I did confirm that my ex-husband, he called for a welfare check again. Something about a court team. And because he had answered questions and refused to come out, he is still at our house. He has barricaded himself in at this point. He did acknowledge that he's not on his medication. And because we had concerns of how he was, like using the restroom and stuff, he did also state that he had like a portable urinal to use because he has been homeless for sporadic time here and there. And because these 4, requests for assistance did not result in the threat being removed, I am present to request a TPO.
Sure.
Because, yes.
Do you feel that there's a risk of harm to you? And
I do. I don't know if he has any weapons, but we do have, because one of the residents is a handyman, there are items, available that could be used. We have an elderly, there are 2 elderly people living at the house that would be at risk. And with my dog too, there was an incident where he took my dog out for over an hour, didn't tell anybody, didn't answer communication when trying to reach out and ask permission. And I went around town trying to search for him, eventually found him. But again, that's my dog under my ex-husband's possession and care.
okay.
So
All right.
I am concerned about that too.
Okay. Thank you.
Yeah.
So based on the information that you've provided, under 13-14-104.5, upon review of the evidence that's presented at this ex parte hearing, if the court finds that there is a risk or threat of physical harm or the threat of psychological or emotional harm, I can issue a protection order to prevent any kind of assaults or threats. I find that the information that was been provided today by Ms. Linehan supports the issuance of a temporary protection order by preponderance of the evidence that there is a risk or threat to injury to Ms. Linehan and arguably the other residents there as well. And so I'm going to go ahead and issue the temporary protection order. I'm going to go ahead and order that he have no contact with you. I can't include a dog on a protection order. It's your property, and so you have the ability to say, it's mine, no one can do anything. I just don't have the ability to add Aspen to the protection order. But I'm going to order that he stay away from you. That also that he stay away from the residents at the 847 Quebec Avenue in Longmont, and he stay 100 yards away from that location as well as any location that you're likely to be found. And then what I will do is I will set this case for a return for a permanent protection order hearing.
We have definitely 100,000% have had judges put a protection order on the dogs before. 100%. We've seen them here. So either those judges were breaking the law or this judge is lazy, one of the two.
And that will be on June 26, 2026 at 2:30 p.m. And that's going to be in the courtroom right next door. And so that's a week from this Friday.
Okay.
What's going to happen at this point is my clerk is going to get together some paperwork. She's going to give you a copy of the temporary protection order. You're welcome to photocopy that so you have extra copies if you need it. You can give it to your roommate so they know that he's not supposed to go to the residence, those kinds of things. And then I will also, I'm going to authorize something called a civil standby, which allows him to get some items from his property to kind of make it to next Friday. So toothbrush, changes of clothes, those kinds of things. I'm also going to give you what's called a service packet. That service packet will have information. You can either go through a normal process server or you can go through the Boulder County Sheriff's Office, but you'll have to deliver that packet to some uninterested third party, the sheriff or a process server.
I remember that. I remember the little dog in Judge Judy's courtroom where the dog had to pick the owner and he picked the guy, right?
Have him served, Mr. Lopez served with the protection order. That's how it would become enforceable by law enforcement. Does that kind of make sense?
Yes, I tried to do, some research beforehand,
Okay.
but yes.
Any other questions I can answer for you?
I don't believe so.
All right.
This time, but thank you so much.
Absolutely. Go and have a seat and my clerk will get this out in just a second.
Jesus, stand by. Yeah.
So first to this, and then I can say something. We need to let's take down. Tell me about the trans. Oh.
Well, she got her protection order. That's another one, though. If he's on his meds, he's probably fine. Now they're having big issues, and there's no help. It's criminal now. Ugh. We need better mental health care. All right. This prosecutor wants a lot. Oh, wait. We already... No.
And then I'm ready on Mr. Rico whenever everyone's ready.
This is different one. This is different.
All right, looks like we're nearing the end here, so I think if we just power through, unless anybody needs a break at the moment. Anyone need a break at the moment? Okay. This was, which one again?
Mr. Rico.
Rico, 26 CR 1456, People versus Luis Rico. Actions of appearance, please.
On behalf of the people.
Jordan Vinovich from the Public Defender's Office on behalf of Mr. Rico, who's appearing in person in custody.
Good morning, Mr. Rico. Good morning, John. We're scheduled this morning for hearing on advisement. Ms. Vinovich?
We can waive all reading and advisement by the court pursuant to Rule 5. I do have a signed protection order and a signed affidavit of firearm relinquishment with no objection to their contents. Have you served in the U.S. military? Mr. Rico does not have any U.S. military experience, if I may approach.
Yes, please. Thank you. Any record from the people or VRA record regarding the protection order?
Your Honor, we are only VRA compliant via attempt this morning.
All right, Mr. Rico, I'm going to talk to you about the terms of this mandatory protection order that will enter in your case this morning. I'm holding up the front page now. On the back side of the front page, there's a signature. Is that yours? Yes, sir. All right, this order names you as the restrained person. It names Shahelia Holt as the protected person. The order does involve a crime of domestic violence and a Victims' Rights Act offense, and it will contain the following terms. First, that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are accused of committing. Second, you will vacate the home of the victims and witnesses and stay away from any location they are likely to be found. Third, you will not contact or have direct or indirect communication with the victims or witnesses. Beyond that, you will not possess, purchase, or control a firearm, other weapon, or ammunition, and you shall relinquish for the duration of this order any firearm or ammunition subject to your immediate possession or control within 24 hours. Do you understand each of the terms of this order?
Yes, Your Honor.
Any questions?
No, Your Honor.
All right, please comply with the order while it's in place. If you fail to do so, you may be held in contempt of court or you may be charged with a new crime, which could be a misdemeanor or a felony. The next document is this affidavit of relinquishment of firearms. Is this also your signature on the backside?
Yes, sir.
This document indicates that you did not possess a firearm at the time the order to relinquish was issued. Do you swear or affirm under penalty of law that information is true and correct?
Yes, sir.
Court will find that the firearm relinquishment provision is satisfied. Argument as to bond, please.
Thank you. We are, of course, requesting that the court issue a personal recognizance bond today. However, if the court is inclined to set a monetary condition of bond, we would ask that the court set bond no higher than $2,500 cash or surety. I would note at the outset that the top charge alleged by the police here is a class 4 felony second-degree assault, but I don't see any probable cause for an F4 in the affidavit under any of the potential subsections under 18.3203. And so I think it would be inappropriate for the court to set bond at the suggested amount for a class 4 felony given that. I would also note that although Mr. Rico's report lists him as high risk, we do note a couple of ongoing matters here. I would also note that he has no prior felony convictions, however. He also does have significant ties to the community, which I think can abate the court's concerns regarding any potential failures to appear in this case. He's lived here for 18 years. He currently works full-time in concrete and construction. He currently lives in Denver. He does not live with the named victim in this case. He lives alone, and he is the only person responsible for paying bills such as rent, utilities, etc. And he does, of course, need to be out of custody making money so that he could keep up with those bills and not face any sort of eviction notice in the future. Moreover, he does also have children. He has a set of twins who are 4 years old. The mother of those children is not the named victim in this case. He also has full custody of those children, given the fact that the mother of those children was just released from custody on her own cases. It sounds like the children are with their grandma right now. However, she can't take care of them long term. And so given that Mr. Rico does have full custody, certainly he wants to be out of custody to maintain a constant presence in his children's lives. He also does have a working phone to be reminded about future court dates through our court reminder program. It also sounds like he has a couple of different medications that he needs to be taking. He hasn't yet seen a nurse. I know that typically folks will go through medical once a bond is set. However, I just wanted to put that on the record. And so we would ask for a PR bond or in the alternative, no higher than $2,500 cash or surety.
All right, thank you. People's position, and I understand you're VRA compliant by attempt.
That's correct, Your Honor. We're only complying via attempt this morning. The people are asking for a full $50,000 cash surety bond for this defendant. That is
They want a $50,000 bond.
scheduled for the allegation of second-degree assault that the defendant may be facing moving forward. We do believe it's appropriate given his failure to appear history, his criminal history, and the nature of the allegations. The failure to appear history is extensive. It's somewhat dating back to 2012, but given the number of relatively recent ones, we do believe that he is unlikely to appear for future court settings. Additionally, looking at the pending matters and criminal history, the defendant appears before this court on allegations of domestic violence. I would point to the case the defendant is on bond in Denver. That's an assault 2. So another assaultive case the defendant is facing. It states in the affidavit that the defendant was In that Denver case, he was on bond. The mandatory protection order in that case involves the same protected party as this matter before the court this morning. That MPO was issued on the 6th of May. So in about a month, the defendant is already violating the mandatory protection order. Under his pending matters on the pretrial report, he's already facing a good number of violation of protection order cases. So in addition to not believing the defendant will voluntarily appear for court, we don't believe the defendant will follow this court's orders. For all of these reasons, we are objecting to a personal recognizance bond or a reduction in bond, and do believe the full setting, $50,000 cash surety, is most appropriate. Lastly, I would just like the court to take under consideration the status of the protected party victim in this case.
All right, I assume the people agree there's no probable cause for second degree assault.
We do, Your Honor.
All right. Well, the court has considered the statements of counsel, the court's own file, and the pretrial bond report in this case. I'll note that the allegations in the case involve second degree assault as an act of domestic violence. The court, upon review of the statement of probable cause, cannot find probable cause for second degree assault. There is no reference to restriction of the airway or blood circulation. There's no reference to a deadly weapon or serious bodily injury of any kind. And there is no reference to an assault on a peace officer. So really, this is a third degree assault statement of probable cause. That being said, the statement itself leaves much to be desired with respect to third degree assault as well. The court does have some victim safety concerns based on the general nature of the allegations in the case. And the bond report rates Mr. Rico at a -5 high risk. It notes that he's on bond on a surety bond of $25,000 out of Denver for a second degree assault case. He's got 4 additional pending cases beyond that. And his criminal history is not terribly aggravated, but he does have an assault as an act of domestic violence conviction in 2018. The failure to appear history is likewise concerning to the court. Looks like somewhere in the neighborhood of nearly 30 failures to appear over the last decade, with a number of those having occurred over the last few years. And so while the court certainly cannot find that a $50,000 cash surety bond is appropriate, having not found probable cause as to second degree assault, I'll find that a slight increase from what would be the guideline amount for third degree assault is appropriate given the failure to appear history and criminal history. And so I'll set bond in the amount of $7,500 cash or surety. Standard terms and conditions of that bond will require no leaving the state without prior permission of the court, and a waiver of extradition, as well as pretrial services with check-ins given the failure to appear history. And we'll set the case for filing of charges, please.
Yeah, we'll set for June 18th, 9 a.m., Division 302.
Yeah, that's not right. Okay, it's not right that he's beating up women. That's not right. But this is America, and you can't just raise someone's bond because he has a bad history. They found no probable cause, and really, really shaky probable cause on third degree. So no, he has his other cases where they have probable cause that he's getting charged with, and he's going through the court system on. I very much disagree with what the judge did right there. If they don't have probable cause, you can't prosecute. You can't just take shaky probable cause and then say, "Oh, I'm going to raise your bond because of your history." No, that's not how it works in America. I don't agree with that judge on that one. That one bothered me. Yeah, he's a POS, abso-freaking-lutely. But just because he's a POS doesn't mean nothing. We have laws. Oh man, now this guy. Get ready, guys.
And I have number 37. Ms.
Yeah,
Ortiz.
they can use your history if you broke the law. But everything they said right there is they don't show enough that he broke the law. So they raised his bond. But this guy gets what he deserves.
Ramirez.
Who was on,
Not really. You know, I think that they should prosecute these cases as murder. I think they have enough evidence that this sort of case could be murder. I don't know. You'll just listen and see. Maybe it's not murder.
who was the lawyer we appointed for Mr. Douglas, for Kiki Douglas?
Mr. Manina, can we call your case next? I'm just scared we're going to lose him.
Yes, Judge.
Okay, all right. Number 36 and 37, 24 CR 3268, 24 CR 1278, both people versus Antonio Ortiz Ramirez.
Brian Hall for the people. Your Honor, I believe there's a total of 4. There's also 2.
Oh, I'm sorry. I skipped the second page. Thank you. We'll also be on the record in 26 CR 941 and 25 CR 4667. It's 4, right? Those are all people versus Antonio Ortiz Ramirez.
Brian Hall for the people.
Greg Daniels on behalf of Mr. Ortiz Ramirez. He appears in custody.
Good morning, Mr. Ortiz Ramirez.
Morning.
All right, we are set for arraignment on the new law violations and status on the other cases. I know there was a motion filed to address bond. How did you want to proceed?
Maybe, but if he's in violation, then that's a different charge. And he gets charged with that. And then they could raise his bond. That's perfectly fine. But what they're saying is he committed this crime and the judge says, no, and they said it was second degree. The judge says, there's no probable cause for second degree. So let's look at third degree. Maybe, but it is really, really shaky. Let's raise his bond. So yeah, if he's in violation of his bond, that is a charge. That is a charge he goes in front of the judge. That's not what he was in front of the judge for today. I just don't agree with shaky or no probable cause, meaning raise his bond.
Mr. Daniels.
Your Honor, as far as the arraignment, Mr. Hall and I continue to discuss all 4 cases. It's going to be a resolution. We're continuing to work on getting a resolution that is appropriate. Part of that is the determination that we're asking the court to make today on bond. And I understand, honestly, he's on 2 deferred judgments that were violated by 2 new cases. I get it. One of them involved a firearm. The other involved stealing a bottle of alcohol from a convenience store. But it was a robbery because of his foolishness, as Your Honor put it, inside that store. So if the court was amenable, Mr. Hall.
I did forget I got 2 cases here. So it's the next case that I think should be murder, not this case. It's the same clip, though.
Paul and I had talked about a date in July where I expect either way we'll have a resolution. But for now, if the court would accept that, then we'll talk about bond.
Okay, I don't have an issue with the continuance. Mr. Hall, do you have any objection?
No objection.
Okay. Bond argument?
Your Honor, last time we were here, Your Honor allowed him to get into Empower online. Gabriel appears from Empower. They've been working with him. In the audience, the first 2 rows facing your audience, Honor, are full of his family on both sides. Also in the audience is Felipe Perez from Grass, as well as a gentleman from Second Chance Center, Ralph Left Hand Bull. They both been working with my client for an extended period of time. Ralph, if you could raise your hand so she could see you. And Felipe, say.
Good morning.
Both of those guys can explain to you what both Second Chance Center and Grasp are. They both known my client for a number of years while he was out drinking. And they've been efforting to help him. My client lost his mom when he was a kid, and it's been a struggle for him. But the reason that we're asking for a bond, he very well, the sentence is going to be up to Your Honor. He's going to be in custody for a period of time. The last charge he has, he goes into a convenience store drunk and steals a bottle of alcohol. He has a continuing alcohol problem. He's 22, and Your Honor knows, I'm sure, how hard it is for 22-year-old kids to get sober and stay sober. And because he's eventually going to get out of custody.
Wait, what? What are you talking about, sir? Yeah, when you turn 21, you go out and you drink a little bit. But no, it's not hard for a 22-year-old to get sober. They're 22. They've barely been drinking.
Regardless of what his sentence is, I want him, he can stay sober in custody as everybody else can. I want him to have the opportunity and experience of being out for a bit but with the help of both the Second Chance Center, GRASP, and the Empower program, all of whom would be happy to address the court, but so that he can develop the tools out of custody while he has that support. Because as impressive, and he has taken a lot of classes, and he has provided me today with all of the classes he's been taking since it's all through May, all since he's been in custody, Judge. He's been in custody since March 2nd. Again, it's easier to stay in custody, sober there, but that's what we would ask the court because he is young, because alcohol has contributed directly to his last charge. Anyway, he's been productive. He's done everything he can to improve himself, and he's taking all the classes he can. And regardless of Your Honor's decision today, I've explained to him to keep doing what he's doing because it's going to last him a lifetime. And I understand this motion may be a bit premature. I understand he's been in custody for 3.5 months, and I understand everything he's facing, but that's why I think it would be important for him to get out now. But obviously, to the extent Your Honor wants to hear from GRASP, Second Chance Center, or Empower, they're here for you. But I know Your Honor has familiarity with most, if not all, programs.
All right, thank you, Mr. Daniels. Mr. Hall?
Your Honor, the people would strongly object to a reduction in bond in these cases. This is a case where community safety has continually been put at risk by the actions of the defendant. As the court knows, 20 JD 430 is the defendant's, one of his adjudications of juvenile. It's an aggravated robbery. He pulls a gun at a stranger, a Domino's car delivery driver, and tries to carjack, steal the money of a total stranger. Put on probation for that case, 21 JD 430. He's charged and adjudicated to prior offender possession of a weapon. And so that's after he's been adjudicated of that juvenile aggravated robbery. He's on probation, and 24 CR 1278 is another aggravated robbery, Your Honor, and this time, again, directed towards strangers at a McDonald's. The court's aware of those facts of that case.
I don't know. He could be with him. I don't know if it's that guy in the jail. I don't know.
Court's well aware of these facts. And it's not only charged that, it's also charged M1, illegal discharge. And unfortunately, it continues, 24 CR 3260. The underlying offense to that case was a palpo, and he pled guilty to CCW.
Thank you.
And then the court knows he was on probation yet again. And he doesn't comply with probation, Your Honor. The court was aware that he did, there was a probation complaint. The court gave him a bond at that point, and of course, unfortunately, he committed 2 new law violations since then. 25 CR 4667, after an argument of disturbance in an apartment complex surrounded by people, defendant gets very angry and goes outside. People are still trying to de-escalate, and he takes the firearm and he shoots it in an apartment complex hallway.
All right, thank you, Mr. Hall. Mr. Ortiz Ramirez, I appreciate the work that you've been putting in while you're in custody, and I appreciate that your family's here. I distinctly remember speaking to you and your father, who's been here with you at every court date. My position, however, has not changed. I think you are a danger to the community right now. I think that you're taking steps to change that, but we're not there yet. I told you when I imposed sentence on that deferred judgment that you were running out of chances, and despite that, the behavior persisted. At this time, the court is going to deny the request to modify the bond, and I'm going to keep you held on a no bond hold on those revocation matters in light of the new offenses you're alleged to have committed. With that record.
So she is sitting in Judge Eric's seat. This is his courtroom before he got moved. And she does a good job. She really does do his job well.
What date in July would you all like to reset? 13th, 20th, or 27th?
I'll defer to the defense. The 13th will be the most difficult for us to have meaningful conversations because I'll be out of town the week before. So I'd suggest the 20th or the 27th.
20th works better for me, Judge.
We will reset Mr. Ortiz Ramirez's 4 matters to the 20th of July at 8:30 a.m. The 24 CR 3260, 24 CR 1278 will be both set for status. 26 CR 941 and 25 CR 4667 will be set for continued arraignment. I'll see the parties back at that date and time. Thank you to the resources in the community. Thank you all for being here. I appreciate you being here. I do understand what your program does and you do good work. I just don't think that this is an appropriate resolution to how we're proceeding here. With that, thank you.
Thank you, Judge. Have a good day.
Good morning, Your Honor. This is John Stockley for the people.
This guy, guys, it's not often we see this level of this type of crime. It's not often.
Morning, Your Honor. Bo Worthington on behalf of Mr. Vargas Tarula.
And Mr. Vargas Tarula is being assisted by our staff interpreter, Ms. Maria Bravo. Thank you for being here. We are set for sentencing today. The court has received and reviewed the pre-sentence investigation report. Are there any changes or corrections to the report?
Not from the people.
Not from the defense.
All right. I will start with the people. This was an agreement to a sentencing range of, was it 15 to 19 years?
That's correct, Your Honor.
I will tell you, Mr. Stockley, I actually went back and looked at the slide deck again because it's been quite a while. And there are numerous co-defendants. If you would begin your sentencing argument, please.
Thank you, Your Honor. Respectfully, the people are asking for 19 years DOC, the maximum under this plea. The structure of this plea agreement, I think, sort of accurately reflects the defendant's major role as a local distributor on behalf of this DTO.
So my apologies.
I'll go slower.
Louder and slower.
Okay, sounds good.
The interpreter is not familiar with it.
Okay. I would just note that the plea in this case reflects the defendant's major role as a distributor on behalf of this organization. The defendant in this case was responsible for either importing, storing, or attempting to sell over 100,000 fentanyl pills, multiple kilograms of methamphetamine, and multiple kilograms of heroin. In addition to receiving and processing these large loads, large quantities of narcotics, this defendant was instrumental in remitting thousands of dollars in drug proceeds through a series of wire transfers to the bosses of this DTO in Mexico, which included his brother, who was really the identified boss of and leadership of this organization. I would just note the nature and frequency of these transactions, as well as the quantity of money receipts that were found at the defendant's home at the conclusion of this case from a search warrant show that this was a regular occurrence for this defendant who was sending money back to Mexico to keep this drug trafficking organization running. I would place this defendant's culpability among the highest of the defendants that you're likely to see in this case. Really, the only individual with more of an ownership interest in this enterprise was the defendant's brother, who remains in Mexico. The defendant in the PSI, I would say, did not take meaningful responsibility. Claims that co-defendant Edgar Godinez Silva was sort of teaching him the ropes of this drug trade. However, I think that's belied by the close family ties to Oscar, the leadership of this drug trafficking organization, as well as the wire transfers that are in the name of other relatives of the defendant. I would acknowledge the defendant has a lack of criminal history, but that's explained, I think, easily by the nature of this organization operating out of Mexico, and this defendant, as well as some other co-defendants, essentially being hired contractors to engage in this trafficking and import these large amounts of fentanyl into our community. Again, I don't think that the PSI shows a meaningful responsibility taken by this defendant, although, I mean, a plea agreement in this case is taking responsibility. But rather than, understanding and acknowledging the harm that, fentanyl and trafficking of fentanyl has on the community, the defendant was more
He
concerned
sure
with
is.
individual dates
Oh, yeah.
that, whether or not he was in the country
100,000 fentanyl.
at the specific time or date charged, but, over the course and the volume of this investigation, including the discovery in this case, shows, I think much of the evidence is against this defendant as far as, looking at this case as a whole. So given the frequency of this defendant, bringing in these large quantities of fentanyl and other drugs, the impact that has on the community and the lack of mitigating circumstances, I'm asking for 19 years DOC. I'm not asking for restitution in this case.
Okay. And so when I looked back at the slide deck from the indictment, my understanding was essentially he's the hell of the cell here, right? So he's on that second rung after the brother that has the current warrant.
Yes, that's sort of where I would place him in just in terms of his, receiving and storing the large quantities of narcotics and then distribution quantities to other drug distributors, essentially.
Okay, thank you. Mr. Worthington?
Morning, Your Honor.
Good morning.
I had filed a sentencing memorandum along with a mitigation report that was prepared by Mr. Vargas Chirula's prior counsel. I filed that on Friday. My apologies to the court for the tardy nature of that filing. I don't have much to add to that except for I do find it always a little vexing. Prosecutors indicate individuals are not accepting responsibility in a PSI when they've signed up to over a decade's worth of prison time. So I would take issue with Mr. Stockley's characterization of accepting responsibility. I think that the mitigation report that we submitted in this case does a very good job of giving context to this conduct. And I think it's very expository in that fashion. And it's likewise very, I think, mitigating as well. And so, Judge, our request for the minimum under this plea agreement, 15 years, I think adequately addresses the statutory factors the court is to consider. And I think it also imposes a very just resolution in this case.
Mr. Vargas Chirula, you don't have to make a statement before I sentence you, but if you'd like to tell me anything else, I'm happy to hear from you. I did I'm sorry, and I forgot to mention that when I called the case on the record, I did see the social worker report and your statement. They're still impending, but I reviewed that over the weekend.
Thank you.
Did you want to make a statement, sir?
Yes.
What would you like to tell me?
Quiere decirme.
Primero, más que nada, buenos días.
First of all, good morning.
Good morning.
Y con todo el debido respeto que se merece usted y los presentes, les quiero pedir un perdón por el error que yo he cometido.
With all due respect to you and to the other professionals present, I want to apologize, to offer an apology for the mistake I made.
Y que estoy verdaderamente arrepentido por el error y estoy dispuesto a pagarlo.
I am truly sorry for my mistake. I am very willing to pay for it.
Y también quiero expresarle la experiencia que pasé con la abogada anterior, que me habló de la pena de muerte.
I do want to mention that I had the kind of experience I had with the previous attorney who even mentioned the possibility of a death penalty.
Que si no aceptaba lo que me estaba ofreciendo el fiscal, que usted me podía dar la pena de muerte. Y eso me dañó, que por poco me quito la vida.
She told me that if I didn't accept what the DA was offering, I could be sentenced to the death penalty by you, and that really affected me. And I was pretty close to taking my own life.
So we don't have the death penalty in Colorado State Court.
Pues la abogada me estaba presionando para yo aceptar
Yeah, the attorney was pressuring me to accept it,
Y esa fue el motivo por la que yo la despedí.
and that was the reason that I asked to get her fired from my
Okay.
case.
But the plea agreement that you've reached now,
Acuerdo al que usted ha llegado.
you didn't accept this current plea agreement as the result of any coercion with Mr. Worthington, correct?
Del señor Worthington. No.
Okay. Okay.
Okay.
Anything else you want to tell me?
¿Qué más que me quiere decir?
Y pues del tiempo que yo tengo aquí preso, aquí me enseñaron a valorar mi vida, a enfrentar mis miedos y sobre todo a saber sobrevivir. Porque la verdad que aquí estar preso es triste la vida.
The time that I have been incarcerated has really taught me to value my own life, to reflect, and also because the time that I have been and how to defend my own life, because it has really taught me some skills being incarcerated.
Okay. Good.
Y yo me pongo a su disposición y yo acepto lo que usted decida para mí.
So I put myself in your hands, and I will accept what you decide.
Thank you, Mr. Vargas Tarula. Here's what I will say. I do think you're accepting responsibility because you've accepted a guilty plea here, but I do think you've minimized your role in this organization. And I understand why you would do that, given the familial connection that you have. I went back through what was presented to the grand jury, and the quantity that was seized from your residence of drugs is just astounding from my perspective. I do hope that your time in the Department of Corrections is going to be of some benefit to you. You're still a young man, and you'll get to return home to your family. But having said all of that, I think if I imposed anything less than the 19 years, it would depreciate the seriousness of what this organization has done to the community that I serve. As a result of that, I am going to sentence you to 19 years in the Department of Corrections. That sentence will be allocated as follows. As to count 1, the Class 2 felony, the court will impose a sentence of 19 years in the Department of Corrections. As to count 3, the money laundering, the court will impose a sentence of 8 years in the Department of Corrections. As to the drug felony 1, the court will impose a sentence of 8 years in the Department of Corrections. That's count 24. As to count 25, the court will impose a sentence of 8 years in the Department of Corrections. Count 1, count 3, count 24, and count 25 are concurrent to each other. So that means that my sentence on count 1 is the controlling sentence. It's a sentence of 19 years in total. That sentence on count 1 will be followed by a mandatory period of parole of 3 years. The parole period on count 3 is also 3 years. And the parole period on the drug felony ones are also 3 years. All of those sentences are concurrent to each other. Mr. Worthington, the PSI indicated 696 days of pre-sentence confinement credit. Is that accurate?
Yes, Judge.
The court authorizes pre-sentence confinement credit of 696 days. The court waives waivable fees and costs in light of the lengthy incarcerative sentence. The court finds that there is no pecuniary loss as a result of your conduct and therefore does not order restitution. Mr. Vargas Tarullo, I hope that you're going to make some changes in your life when you're released from custody and get back to the family that I read about in your social worker report. I do wish you the best, sir. Thank you.
Muchas gracias.
Thank you very much.
How many people die every day from fentanyl? He should get a murder charge. And same here. Me taking a sick day at work was unheard of. It just would have never happened until it did. You know, I mean, I never got the flu. I never got sick until I started getting sick. All right, removed from major drug dealer. We already went through 4 clips. Guys, we're going so fast today. All right. This guy just does not want to take the domestic violence classes. He just does not want to take them. We'll see what the judge has to say. It's ridiculous. This whole thing is ridiculous. Here we go.
Court calls 25M1841 People v.
So most of this, the audio is fine. There's a few scratchy parts, but most of it, the audio is fine.
Daniel Banjo, who appears in person with counsel, Mr. Jerdeman, Ms. Krug, Ms. Brink for the People. This matter comes on for sentencing after a jury trial where Mr. Banjo was convicted of count 2 of the...
Yep, it was a full jury trial. Wait till you hear what he did.
Unlawful tampering, the criminal tampering, class 2 misdemeanor. The court allowed the parties to brief the constitutional vagueness of the statute. The court had previously denied a motion to dismiss based on constitutionality or vagueness of the statute. And at the end of trial, counsel had renewed their motion regarding the unconstitutionality of the statute, and the court allowed for briefing. The court has determined again that the tampering charge is not unconstitutionally vague as applied to Mr. Banjo, that the court denies the motion to dismiss that count, and the court denies the motion to vacate the conviction, and that the record is preserved for appeal. The briefs are is there anything addition in the briefs that the court that the parties would like to address?
The only point that I would make in addition is that we're in a substantially different position now than we were at the time the motion was initially denied by the court, because there is now a complete record. And when we're talking about an unconstitutional as applied challenge, which we have now, the issue is whether or not it's unconstitutional as applied to Mr. Banjo's actual conduct and the facts of this case. The court did not have those when it made its initial ruling that it wasn't unconstitutional. The court now has those. We pointed those out and argued those in briefs, and I certainly have some points I'd like to address, but if the court doesn't want me to do that, I won't.
Mr. Jerdeman, and I understand, I see the briefs, and as applied to Mr. Banjo, the jury came back with a guilty verdict on the tampering. I have seen the evidence that was also submitted, and the court sat through the 3-day jury trial with all of the information and the like. And
3-day jury trial. Wait until you hear what he did.
Has determined that in terms of I understand that there was no evidence of altering in any way, and that it is meddling and interfering that counsel has issue with.
I'm not going to lie, Bobby. I love you to death, but I don't want you on a jury. No freaking way. You are not qualified to be on a jury. You are biased. It doesn't matter what the crime is. It doesn't matter who is in the stand. You, sir, are the definition of bias.
But I believe that the jury was able to find that Mr. Banjo messed with this bag that even though they had said that it belonged to him, he knew in his own words and testimony, or not testimony, but recorded, he himself said he knew that the information, that her things were in there and that it was a tit for tat, that, if she's going to do that to him, he's going to do that to her. And again, two wrongs don't make a right? Maybe she didn't get charged with it, but if two people are speeding and only one person gets caught, it doesn't mean that the other person wasn't speeding, but that person was speeding and applied to them. In this case, the jury found that she was tampering. Could they have found that Ms. Smith was also tampering if she was charged? Yes, possibly, but that's not the case before us. And so, but as applied to Mr. Banjo, the court finds that it is not unconstitutionally vague. But if you would like to supplement your record to make any points, I will allow you to do that.
I am not going to lie. Sometimes I get clips just to hear what Micah is going to say about their name. But this one is also pretty good.
I very much appreciate that, and I'll try to be very brief. With respect to the court, our concern is that in describing criminal conduct, to be a crime, there has to be an act and there has to be a culpable mental state. So when you describe the act as meddling, that conduct, as the court just said, messing with something, that can be any conduct at all in relation to someone's property. When you describe conduct as interfering with something improperly, any conduct that a person engages in with respect to another's property could be improper if it's performed with intent to annoy or inconvenience. And I say this, and I said it in the brief, but the reason that I'm so adamant about it is I, as an officer of the court, believe that there is controlling authority from the Colorado Supreme Court in a case out of Boulder, Longmont versus Gomez, where the court specifically dealt with a statute that said if the conduct that is criminalized could be any conduct, then that statute does not provide the requisite limiting standards. And that's exactly what happened in the Gomez case. And we're talking about any conduct. There is no description of conduct in tampering when you're talking about meddling or improperly interfering. It is not, the statute doesn't provide a readily identifiable objective standard for measuring the conduct. And Gomez, our Supreme Court says that's not good enough, because what happened in Gomez, basically, because the statute has no objective standard, it allowed basically Deputy Hart to decide which of the actions was improper. You have a situation where
Gomez is a different case. So this is a different case he's talking about.
Mr. Banjo was trying to get in his car.
This is Mr. Banjo, so this is the one we're talking about.
She's stopping him from closing the door. She's obviously trying to stop him from leaving. She's inconveniencing him to the extent that he has to walk away. She's trying to take the construction materials he bought. She's trying to move his other items on his dresser. The reason
that Hart could charge Mr. Banjo and not her is because he's dealing with a statute that says, oh, if you mess with somebody's property, then that's the crime. And that doesn't provide a standard of what the criminal conduct is. So the act here is not defined significantly to give law enforcement a standard of how to apply it in a way that's not arbitrary. And secondly, to basically create a situation where there's not fair warning of the conduct. The court mentioned the tit for tat argument. That the DA mentioned that. I understand where you're coming from, but here's the deal. Mr. Banjo, in saying tit for tat, wasn't saying she committed a crime, so I'm committing a crime. Mr. Banjo said she was messing with my property, which never occurred to me could be criminal, and so I messed with her property, which never occurred to me could be criminal. And the only one who decided it was criminal was Deputy Hart, because he had no standard to rely on in making this decision. And the statute in Gomez that they found unconstitutional was actually far stricter than our statute. Because in Gomez, the intent, first of all, had to be threaten or abuse or harass, and the conduct.
I'm going to tell you what he did. I'm going to tell you the act that he did that created a 3-day jury trial. He moved his bag from one spot to another, and his bag had some of her stuff in it.
Actually had to, in fact, harass, threaten, or abuse another person. And even then, the court said, because you did not define the conduct in a reasonable way that with an objective standard for measuring the conduct, because you didn't provide an objective measurement for the conduct, even though the conduct could actually cause somebody to be threatened or abused, which in our statute is not required. In our statute, the victim doesn't even have to know that the property was messed with. That's not part of the statute. And the intent to annoy or inconvenience is far more vague than the intent to threaten or abuse another person, which was the Longmont statute. Yet, the Colorado Supreme Court, in a Boulder case, said that statute is unconstitutional. And we were, these words, we're not cherry picking them. I mean, what happened is when addressing the act element of this crime, Ms. Dwyer said to the jury, the definition of tampering means to interfere with something improperly, to meddle with it. Mr. Banjo meddled with this property here. So either one of those things, combined with the culpable mental state, which she also argued was to intend to inconvenience her or annoy her. If you take an intent to annoy and you combine it with meddling, that's the basis of the conviction in the case. And that is a conviction for conduct that is not.
All right, Bobby. It sounds like you've got the annoy part down for Monica and V. That's one half of this crime. You better be careful. You're moving into felony territory. And then if we apply your logic to your crime, Josh is right, Bobby. You will have to go to prison for 19 years.
Adequately described as required by the Supreme Court in the Gomez case. And that's the reason that we are asking the court to take another look at that, because I think Gomez is exactly on point. I mean, the issue in Gomez is, what do you have to say about the criminal conduct? What is it about the criminal conduct that you must say in a statute to have that statute not be vague? And Gomez says there needs to be a readily identifiable objective standard to measure the conduct. Meddling does not provide an objective standard for measuring the conduct. Yeah, the jury found he messed with the property. That's what the prosecution said. That's what he did. But when you talk about interfering with something improperly, if that's any conduct that someone does with intent to annoy someone else in relation to their property. When you talk about meddling, that's any conduct. That's exactly like Gomez. And I, out of respect for the court, stop talking. Thank you.
Thank you. Ms. Brand, any additional info you'd like to make? Right. I understand the arguments, and I have read the Gomez case, and I understand that the jury came back with what it came back with. The court will uphold its ruling, and we will, that issue again is preserved for appeal. We will go to sentencing. Ms. Brand, your arguments for sentencing, please.
Now, when Mr. Banjo comes before the court being convicted of tampering in the second degree as a crime of domestic violence, a class 2 misdemeanor. The people do recognize that this is a class 2 misdemeanor. However, this court sat through 3 days of jury trial and heard the immense impact both on Ms. Smith and also on her children, one of whom testified both in the motions hearing and at trial. The people are requesting an 18-month period of probation, domestic violence evaluation and treatment, parenting classes for probation, such as nurturing parents program, mental health evaluation and treatment, no weapons, and to continue to abide by the restraining order. In addition, we are requesting the costs of prosecution, which have been provided to defense in the amount of $428.88. That is expert fees that were taken on by the state to prepare for trial, as well as trial fees. The people would note, again, that this case was clearly part of a larger relationship. Ms. Smith testified for hours on end and detailed some of that relationship and some of the issues within the relationship. That being said, what occurred on this date is clearly that Mr. Banjo committed an act of domestic violence, and for those reasons he should be held accountable. The people also do know he does have a prior felony conviction, though it is from 2007. Otherwise, it does not have much in the way of criminal history. I do have a statement from the victim. And for the record, Ms. Smith is present over WebEx, but she specifically notes she's choosing not to speak for herself and to appear only by WebEx because the entire process still feels unsafe to her, and her ask has always been the same for protection and safety for herself and her children. She would like the court to understand that the harm did not begin or end with the assault and did not end with the trial. It has continued all the way the case has been defended, the way her children have been harmed, the financial devastation she has experienced, and the way the court processes have continued to allow them access to her life. The parameters, she notes during the second civil assist is one example, when the court authorized process became another way for Dan to enter her home and property with his attorneys, law enforcement, and private investigation. Dan did not come to take the items from the list that had provided by his attorneys in advance. Instead, he spent hours walking through his home and his properties with his private investigator. That did not feel like a good faith attempt to retrieve belongings, which is what a civil assist is supposed to be. Instead, he used the charade created by the assist to bring additional court proceedings against him, and he is using this as proceedings to this day. She wants the court to understand that even procedures meant to be neutral can become unsafe when it gives permission for an offender to continue to intimidate, survey, and control. The process should be used for what they're designed for and not to allow further abuse. She also wants the court to understand what this has done to her children. Her son had to testify. He had already been forced to relive these events to forensic interviews and accounts to police, and then had to sit in a courtroom on multiple occasions while his father's attorneys accused him of lying. His father knew the truth and still allowed his child to be put through this. Then his father blamed her for the son not wanting to see him. Her son continues to suffer. Both of her children continue to suffer. This has affected their sense of safety, trust, stability, peace, and belief in our justice system, and it will remain with them for the rest of their lives. She notes that Dan has continued to use her sexuality and identity as part of his defense narrative. They have publicly outed her, exposing private parts of her life, and tried to twist the issue to claim that he was under duress because of being on it. This is not a community Dan has ever claimed to be part of, yet he's used that community and her identity as a weapon in this case. This has been humiliating and deeply traumatizing. She had to sit in a courtroom and listen to deeply personal parts of her life be disclosed, discussed, distorted, and twisted against her. She was painted as homophobic while the actual issue of Mr. Banjo's violence and accountability were pushed aside. She also wants to report to understand financial devastation she has incurred. Since his arrest, Mr. Banjo has devastated her financially. He's been able to afford attorneys, private investigators, and ongoing legal tactics that have prolonged this case and all of the other litigation he's got against her. Mr. Banjo can afford to pay to avoid accountability. Meanwhile, her children and her need with their safety, security, finances, and emotional health. She also wants the court to know what happened after a trial. She unexpectedly ran into a juror at Trader Joe's. He spoke about what the jury voted the way he did. He said the jury struggled with specific jury instructions and the distinction between whether Mr. Banjo acted knowingly or recklessly would be fulfilled. She understands there's limits to what we consider about jury deliberations, but that conversation matters because it confirmed what she's been saying, not whether she or her son are telling the truth, not because the harm did not happen, and because Dan's conduct did not happen. This matters because her son still had to testify. He still had to be cross-examined. He still had to live the trauma, and they struggle with the consequences of that. What she wants most is for the court to protect her. She wants the court to recognize the harm has continued through intimidation, litigation techniques, tactics, financial coercion, public disclosure of her identity, and continued threats to her home and life. She's asking for the strongest protections available and clear limits on abuse. She notes an order of protection is supposed to prevent more than direct physical conduct. It's supposed to prevent threats, intimidation, harassment, and force of control. She needs support to understand that safety is not just the absence of direct contact. Safety needs limits that actually disallow coercive control, litigation abuse, intimidation, surveillance, financial manipulation, and any use of court-authorized processes to continue to threaten or control. She wishes for an order of protection that's specific and forcible.
Just so you know, we're going through all of these words that this woman is saying for absolutely no reason. Because she's talking about domestic violence and blah, 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 blah. He's here for menacing. That's what he's being charged with. Menacing. Because he moved the backpack. So none of this matters.
Strong enough to stop Mr. Banjo from using third-party legal processes, private investigators, or lies as workarounds and continue harming financial control. She asks for a sense of safety at the most fundamental level to having a shot at chance to heal.
Mm-hmm. Counsel.
As an initial matter, and I know the court understands this fully, the sentencing here today is for what Mr. Banjo was actually convicted of moving his own backpack with Ms. Smith's property inside. It is not for an assault of which he was acquitted. It is not for any other long list of complaints that Ms. Smith might have, whether truthful or fabricated. It is not for what is going on in other litigation matters. It is not for whether or not a child had to testify. It is for moving a backpack. And our sentencing statute, CRS 18-1-102.5, tells the court must look to the nature of the crime and sentence accordingly in line with the nature of the conduct, factoring in any additional mitigation factors. Here, even though the court did not find the statute.
And then because of this, the menacing was as a form of domestic violence. And because it was as a form of domestic violence, one of the possible penalties for Mr. Banjo is that he's going to have to take classes, domestic violence classes. And that part he violently objects to. I mean, we're not going to hear him violently object, but his attorney is going to violently object. He does not want to take these classes at all. So that's the whole crux right here. Is he going to have to take domestic violence classes because he moved his own bag that had her belongings in it?
Constitutional, it is, as applied, it is hard to think of an example of more minor conduct that would lead a person to find themselves criminally charged. Even in everything that Ms. Smith has said in her statement about how terrible Dan Banjo is, you did not hear one thing about how Mr. Banjo moving the backpack negatively impacted her, because the truth is that impact was negligible. And the other extraordinary fact of this case is if Mr. Banjo could be convicted for moving the backpack when he, for tampering when he moved the backpack, Ms. Smith could have and should have been charged and convicted, perhaps convicted of multiple counts of tampering, as the court observed, for moving his soap, moving construction equipment, blocking a car, refusing to let him leave. And that brings me, I think, to one of the most remarkable pieces of evidence that I have ever seen in my years of doing this. And that is the recordings of Ms. Smith deriding Mr. Banjo in the most vulgar and disgusting way possible. And those recordings, I think, really demonstrate better than how anything I could put into words.
Oh, I'm 1,000% sure I've said worse things to my ex-husband. So no matter what she said on those recordings, I was worse.
Who is the aggressor in this relationship? This is the heart of an extremely complex challenge for the court. If the court sentences Mr. Banjo to probation, and I believe he would be extremely successful on probation, it must include domestic violence classes. But are those classes appropriate in these circumstances? Is it a good idea to make the victim of intimate partner violence complete classes as the so-called offender? And there's a lot of research on this, and it's referred to as bilateral violence in the research. And I brought a study for the court that highlights some of these issues of bilateral violence and the conduct of conjoint treatment. And this obviously is not a case where conjoint treatment is going to happen, but in many ways, that's the type of treatment that is appropriate under these circumstances. Further discussion of things like been alleged, he's now been left of them. And specifically, the study points out that there are different types of intimate partner violence that happens in relationships. And most intimate partner violence involves, it was believed that most intimate partner violence involves a male perpetrator and a female victim. But the reality is studies showed there's much more gender symmetry. And when there is bilateral violence, the most effective treatment is conjoint treatment, meaning both parties have treatment together. And the case or the study notes when addressing only one partner's violence, when both partners use violence when conflict escalates, is unlikely to result in a home without violence. And that's specifically in the context of partners who wish to stay together. But I think it's still demonstrating the issue that people in domestic violence research are wrestling with now, which is how do we address conjoint violence? How do we address the bilateral violence? And I have one more study for the court. And this is from the American Journal of Preventive Medicine from 2024. And the study essentially talks about how the one size fits all DV treatment isn't actually evidence-based and doesn't help in these circumstances that aren't the traditional male perpetrator, female victim, and how it can be quite ineffective. And so the court sentences Mr. Banjo to probation and he is forced to do DV treatment. It's not in the curriculum of any DV provider in Colorado to step back, to recognize this is a relationship with bilateral violence. This is a relationship where you were certainly the victim of certain acts of domestic violence. Instead, there's this black and white labeling that goes on. And if we believe the purpose of the courts and the criminal justice system is to truly do justice, to right the wrong, where all individuals are equal before the law, it simply does not make sense to require Mr. Banjo to complete domestic violence classes where he's going to be viewed as the perpetrator and the aggressor. And perhaps one day, DV classes in Colorado will evolve to recognize this level of complexity in domestic violence relationships, but they are not here yet. And the solution I have for the court, and I know this is a very unconventional proposition, but again, this is an unconventional case to say the least, is for the court to sentence Mr. Banjo to 1 day jail with credit for 1 day time served. That is the only way the court can protect him versus someone who is the victim of bilateral domestic violence from being caught in this continuing cycle of unequal treatment. And there are other reasons why that sentence makes sense. First, if moving one's own backpack is a criminal act, it is the kind of criminal act that should be punished with a minor sentence like 1 day jail, a fine. 18 months of probation is completely excessive. Second, the court knows Mr. Banjo has taken these proceedings extremely seriously, obeyed all court orders, faced false allegations and an arrest on Thanksgiving, where he spent Thanksgiving Day in jail and the whole long weekend in jail, and has made meaningful personal changes that you see in the letters of support, including seeking therapy. Third, the largest and most damaging punishment that Mr. Banjo has faced is also something out of this court's control. The protection order allowed Ms. Smith to separate Mr. Banjo from his children. And despite court orders in the DR case, 10 months later, he has not seen them. When he was arrested, he had an extremely positive relationship with both children. He woke up at 5 a.m. to drive his daughter to swim practice every single day. He made his kids dinner. He talked about their day. Now his children profess that they do not want to see them. And that is extremely upsetting to.
I mean, he did call his son a liar in front of everybody when his son took the stand to testify. So, yeah, you can blame her, but there's that.
To him, and frankly, a much greater punishment than anyone should have to bear. Fourth, there is a lot of data that shows that DV OMB treatment is not a meaningful intervention, especially in low-risk offenders like Mr. Banjo. And low-risk offenders are often overly criminalized by DV treatment and assessed at the wrong levels. And there is very conflicting data, as I mentioned, on whether someone who is also the victim of domestic violence or intimate partner violence should be forced to do treatment if they are arrested in the context.
Ma'am, you keep saying that. I get it. You keep saying that, but I don't know what she did or didn't do, but she was not found guilty by a jury of domestic violence. He was. And again, this is stupid. He moved a backpack. I don't know why they found him guilty of domestic violence. We didn't hear the whole trial. But he was convicted of domestic violence by menacing. So you need to stop saying, yeah, well, she was too, so he doesn't have to do domestic violence classes, because that's a stupid argument.
Of a bilaterally abusive relationship. The argument I heard from the prosecution was that black and white thinking. DV conviction, DV treatment. But this case is anything other than black and white. And so if the court were to follow the defense's suggestion for 1 day jail credit for time served, Mr. Banjo has the permanent conviction. He has to live with that conviction. He definitely made a mistake by moving the backpack and engaging in the argument. He went to jail. He served an appropriate amount of time. This chapter can close. We can all move forward. What has happened to him is
I think I know. I don't know, but all right, this would make sense. If her cell phone, her car keys, her money was in that backpack, and he like moved it to hide it, so that she had no way of contacting the police, she had no way of leaving, she had no money. He took all of her escape routes away from her. That would definitely 1000%, which I've used 3 times in this stream so far, 1000% be an act of domestic violence. So that could have been it. It's the only thing I can think of. Did you guys think of anything else?
fair and so far as fair in terms of punishment. And if the court believes probation is appropriate, then again, the character letters demonstrate that Mr. Banjo is an intelligent, empathetic person who is open to change and will no doubt be successful in completing probation. And he will likely do so as quickly as possible.
I don't know if I'm allowed to say this. I probably am not allowed to say this, but I really love Jell-O pudding pops. And I can't find them anywhere anymore. And I thought they were delicious.
So we'd ask for the option of early termination. Once again, all substantive requirements have been met. And then I just briefly want to address some of the requests from the prosecution. There's a request for a mental health evaluation and treatment that is completely unnecessary. There was nothing in the evidence that suggested that Mr. Banjo has any kind of ongoing mental health issue that needs to be continued. I would suggest to the court that suggestion from the prosecution is to provide Ms. Smith with an advantage in other cases. The suggestion for a parenting class, again, there's no suggestion in the evidence whatsoever. The children were involved in the act that he was convicted of moving a backpack. That, I think, is an inappropriate suggestion based on the evidence. I also think parenting issues are properly handled by the DR court. And in terms of the costs...
Nuh-uh, they were talking about fudgesicles. That's in the same thread. I'm just multitasking. I'm listening to court and reading chat.
I don't know that... I understand the prosecution says we received a bill of costs. I don't know that I did receive a bill of costs or noted that, but I would note for the court that costs must be related to the charge he was convicted of. And so to the extent that there was an expert who came to testify on DV, there are 2 charges here. I think at the very least the costs should be split in 2, but I also don't know and haven't seen the bill of costs in enough detail to know whether those costs are associated with the prosecution's attempt to prosecute Mr. Banjo for 3rd-degree assault, which resulted in an acquittal. And so we would ask the court not to order any costs that might be attributable to a prosecution for an acquittal.
Thank you. Mr. Banjo, you don't have to say anything. If you would like to, the court would listen at this time.
And, Your Honor,
did one other...
No, I would just let the court know that counsel is advising Mr. Banjo to remain silent due to the fact there may be an appeal.
Your Honor,
Ms. Brand.
I do want to make it very clear that the court has no option, unfortunately, regarding sentencing in domestic violence cases. 18-6-801, subsection 1A makes it clear that when the defendant is convicted of a crime with the underlying factual basis of domestic violence, which Mr. Banjo was convicted by a jury, the court shall order treatment unless he's sentenced to the Department of Corrections. That would not be the case if he was sentenced to 1 day of jail. So in that, even if the court were to impose that, he would need to participate in domestic violence evaluation treatment per the statute. And assuming that the court is quite aware of how our domestic violence evaluations and treatment go, I would rebut some of the statements from defense. They do provide an evaluation of a defendant. It is not a one-size-fits-all process. And considering the fact that he does have that conviction, that the conviction was determined by a jury, that the court does not have the ability to ignore that sentencing requirement under 826-801. In addition, I do want to clear the record. The defense was provided a copy of the invoice from Ms. Watkins. And it was provided. And, I don't doubt, I'm not contesting that we didn't receive a copy of an invoice. I just didn't receive a bill of costs. And so I had no idea that the $428 is related to the invoice from Ms. Watkins. But if that's what it's related to, I think there's further record to be made. Your Honor, we provided an invoice from Jennifer Walker. The defense was clearly aware that that was the people's expert that was set to testify in this case. She was set to testify about domestic violence in general, which was obviously an issue until the court determined that she was not permitted to testify. It is an appropriate cost of prosecution, and the court should impose that. And yeah, thank you. To the extent that the DA has now clarified that the $428 is for Jennifer Walker, she was not allowed to testify. There is no basis for awarding costs on an expert who was not allowed to testify and who in fact did not testify. And I think her testimony primarily, again, went to the third-degree assault charge rather than the tampering charge. And so I think it's inappropriate to allot the full amount of costs. I believe in the first instance, it's inappropriate to allot any costs for an expert who did not testify.
I will check.
But secondly, the full amount would be error.
Is it the defense's position that the court is allowed to sentence him without having to order the domestic violence evaluation and the treatment?
Yes, and I was just trying to pull up the statute again. My understanding is the domestic violence evaluation and treatment is only a requirement if somebody is on probation.
That's incorrect, Your Honor, and I apologize. It is 18-6-81. I can read it for the court. In addition, that is any sentence imposed upon a person for violation of any criminal law under Title 18, any person who is convicted of any crime, the underlying factual basis of which has been found by the court on the record to include an act.
Snoozat, it was good to see ya. Have fun with your daughter. Your hips are screaming at chat.
Of domestic violence as defined in Section 18-6-800.3, whether or not such a felony crime is a felony, when such crime is used as a method of coercion, control, punishment, intimidation, or revenge directed against a person with whom the person is or has been involved in an intimate relationship, shall be ordered to complete a treatment program and a treatment evaluation that conforms with the standards adopted by the DVOMB as required by Section 16-11.103, subsection 4, except the person who has been granted probation that is transported to another state shall follow the requirements for a treatment evaluation and program of the state where the person is being supervised, except for a person granted probation whose supervision is transferred pursuant to the interstate compact. If an intake evaluation discloses that sentencing to a treatment program would be inappropriate, only then shall the person be referred back to the court for an alternate disposition. And then it is specific, subsection, it's part 2, subsection 1 of this section shall not apply to persons sentenced to the Department of Corrections. That is the only exclusion to the rule. And I would note that our Domestic Violence Offender Management Board requires a person to be on probation in order to participate in domestic violence treatment as a probation officer is part of the treatment program and part of the treatment team.
So, Ms. Brand, if somebody doesn't want to do probation, which they're allowed to do, then what is the situation? Then if they don't want to do probation, as probation is a participant, like if they want to participate in probation. So if they don't participate in probation, what is the courts allowed to do?
I mean, first of all, it would be concerning for the people if the defendant's statement at sentencing is that they don't want to participate in any treatment. That's of concern to the people. I would note that if they were to not do court-ordered treatment, that it would be, they could be held in contempt of court for not doing what is ordered by the court. If the court were to order a period of jail, which again would get rid of the protection order at the time that the period of jail ended, with no subsequent probation, and which would order Mr. Banjo to complete domestic violence evaluation and treatment, if he were not to do that, he could be held in contempt of this court, but there's no one to supervise that or determine whether or not that has actually been completed, which is why the Domestic Violence Offender Management Board includes probation as part of their treatment team, sure that all of that is being done in an effective manner.
Ms. Krug, any further record?
I would just note for the court that people who go directly to jail and are not ordered to probation do not do domestic violence treatment because of specifically, again, the DV standard saying you have to be on probation to do DV treatment. So this becomes a very circular argument where I think the court has the ability to say, if you're not being sentenced to probation, I am not required to sentence you to DV treatment. In fact, I cannot sentence you with DV treatment because the standards make it impossible for me to do that. And so I think it is an appropriate and legal sentence for the court to sentence for 1 day jail and not credit for terms.
He was in jail. He spent Thanksgiving in jail. So they just want him to, that is time served.
The court is going to sentence Mr. Banjo to 1 day of jail with 1 day for credit for time served. The court is going to order a DV evaluation and treatment for him to do on his own. The court is not going to supervise that, but the court is going to order it. He could be held in contempt if he doesn't finish it, but the court is not going to order it. I mean, the court is going to order it, but I'm not putting him in information. The court is going to do prosecution for $428.88 with his sentence being completed. The end of there will be court costs associated. Those court costs need to be paid. That's the order of the court. Mr. Banjo, you have the right to appeal.
Well, can I just say one thing? It's totally unrelated, but it relates to the case. I just remembered it when we're talking about did we get notice of things or copies of things. In reviewing the FTR, as I did to prepare the pleadings that we filed, I came across the language where Ms. Brand said that after Ms. Smith testified, she came into the DA's office the next morning and made a number of statements about the trial and the case and about the cross-examination and her preparation, and that Ms. Smith made statements about the case, and Ms. Brand said at that time that she was going to provide us with discovery of that. That's all in the FDR, and that's how I remembered it. And this ticked my mind now when we're talking about if we get notice of the other matter on costs. So I don't believe Ms. Brand has ever followed up and given us that.
Yeah. Your Honor, it was disclosed the day of trial at 9:58 a.m.
I apologize.
Court finds that this case has been pending since September, that there has, that it's an appropriate sentence, and that at this point for the criminal tampering charge, it's an appropriate sentence in this case. The case is now closed, and again, Mr. Banjo, you have a right to appeal, and the costs associated with the order. And that is the order of the cases in recess.
So he does have to take domestic violence classes. All that. A 3-day trial. And he ends up with the day of jail, which he already did. And he does have to take, and he has to pay $400 some bucks for that witness that never testified. If he would have just pled If he would have just pled at the beginning, I know, Bobby, I know you don't like plea deals, but he probably wouldn't have had to pay 400 some bucks plus court costs for the 3-day jury trial. I wonder what that means, that he has to pay court costs for the 3-day jury trial. Does he have to pay? What does he have to pay? What do those court costs does he have to pay for the jurors? Does he have to pay for all of that? Because that would suck. We need a lawyer, guys. We absolutely need a lawyer to hop in our chat and set us straight when we start pretending we know law. All right, it's time for me to head to Lancaster. Gosh, I shall see you all in 22 hours. Behave, be nice. If you're going out to celebrate, stay away from the busy places. Go to the smaller ones this year. Don't go to the big ones this year. I know it's a big freaking year. I know missing the big ones this year is probably the worst. But I don't think it's safe, guys. So, stay home would be the best thing. I want to see you all the week after 4th of July. I don't want to hear any bad news about any of you. Alright, see you in 22 hours. Behave. Bye, guys. Oh, no, wait. I almost forgot the song.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. So in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.